I've spent the past couple of days listening very carefully to the evidence in this case, as well as the explanation surrounding it. And I must begin my summing up by reminding you that as a manager you have certain responsibilities, not only to your colleagues or those who fall under your control or influence, but you also have a very clearly defined legal responsibility. And that is why you are here now in my courtroom. The law requires me to assess everything from the point of view of what a reasonable person would have done in this instance. Also, we have to assess whether all reasonably practicable steps were taken to identify and minimize, as far as possible, the risks and hazards associated with this case. These two conditions have not been satisfied. On the first count, this court finds that you failed to report all the relevant facts of the incident as prescribed by law in the correct manner and to the correct officials. The law asks for a maximum penalty of 50,000 rands or 1 year in prison or both. As this is your first offense, I will show some leniency. On count 1, you are hereby sentenced to a fine of 20,000 rands and a period of 4 months imprisonment. The latter suspended for 3 years. On the next 3 counts, however, where each of the 3 victims were exposed to severe health risks and have indeed suffered irreparable damage, I cannot show the same degree of tolerance, especially as there was little or no training given to these unfortunate people, and there also was a complete lack of proper supervision and control. I pause here in order that you may reflect on the severity of your omissions, as these people could have died. This court has found you guilty of culpable homicide on each of the 3 counts. As you will no doubt imagine, the penalties for this are far more severe: 100,000 rands or 2 years imprisonment or both. As this is cumulative, on each of the 3 counts, you are sentenced to a fine of 50,000 rands and a period of 6 months in prison. This will not be suspended. This court is now adjourned.
In total, the inspectors wrote out over 38,000 contravention notices and served nearly 1,500 prohibition notices in order to get compliance with the present Act.
Nobody would willingly want to become a part of those statistics, nor would they want to expose themselves or their colleagues to the sort of treatment that we've just witnessed. But the legislation has been redefined to provide for some new inclusions. But before we find out what those inclusions are, I spoke to Mr. Mani Mulder, the ex-past Chief Inspector of the Department of Manpower, to find out why we needed to change the legislation in the first place.
Well, as you know, the MOS Act at present does not provide for health matters. It only provides for safety. So in order to cater for the whole issue of health, it has become necessary for a major revision, and we thought to rewrite it in totally. There are other problems with the MOS Act, such as that it is paternalistic. There were other problems with the use of words such as delegation. And it's, after 10 years, it was time to revamp totally. What is required in the law is that the employer, the company in most instances, through its chief executive officer and its management, should manage health and safety like they manage anything else within their business. The example that I've used on many an occasion is, if you speak to a manager, literally any manager in South Africa, and you were to ask him the simple question, tell me, sir, is financial management part of your job? The answer would be, of course, yes. If you were to say, is personnel management part of your job? Again, the answer would be yes. And if you then say safety management or health and safety management, oh no, that's got nothing to do with me. We have a safety officer for that. And I think because of that very fact, the legislator has seen fit to require by law that managers make it their business to also manage health and safety. So the implication is that they have to set up some system within their organizations to address or manage from top to bottom the whole issue of health and safety. It boggles the mind why managers would go to all these convoluted mechanisms to try and indemnify themselves. The simplest way to indemnify yourself as a manager is just comply with the law. And the basic tenet of it is just be reasonable. Do what a reasonable manager in your position would do, and you have nothing to fear. As I said on a previous occasion, inspectors in the courts are not monsters and ogres and expecting unreasonable lengths that you should go to. Just act normally, act reasonably. And if you go about managing health and safety in a positive way, with commitment, caring for your employees, you should have no problem. And you don't have to run to lawyers to try and indemnify yourself at all. If you can demonstrate to managers that something has a direct impact on his bottom line, they are very much inclined to buy into it. Yes, so the whole issue of criminal sanction of the law, I don't think that's the important one. I think the important one is this impact that the management of health and safety has on the bottom line. What determines profitability in an organization? In my opinion, just one word: productivity. And there's a lot of misunderstanding around that word. You say productivity to people, the old Calvinistic, in the sweat of thy brow type of attitude comes forward, and that is not what productivity is all about at all. Productivity is the simple ratio between your outputs and your inputs. And the question is, how much goes in the back door and how much comes out the front door in your business? And if more is going in the back door than what's coming out the front door, you have no reason to remain in business, and you won't remain in business for very long. And I think it is straightforward and simple that the whole issue of employees' well-being, of their health, of their safety, impacts on both the inputs in your business and the outputs. If you have to retrain people because your operator has lost a finger or a hand or an arm or whatever, or if you're losing production because your machinery has been damaged in some accident, on the one hand you're impacting on your inputs, and on the other hand you're impacting on your outputs. The modern way of conducting business is by participative management. In other words, to get the agreement and commitment of everybody within the organization to whatever goes on within the organization. And this is now just made part of that. Yes, it is now a legal requirement to consult with employees on most matters that are done within the field of the management of health and safety. So I don't think it's anything particularly new in the general scheme of things. I don't think it'll be long-winded or cause any major problems. In fact, it's good management to consult your workers and to know what their feelings are and what they think and what they know. One has to be a little bit careful of the use of the word negotiation, because negotiation implies give and take. I will do this if you do that, and I will pay you this if you do that. You know, it is negotiation is horse trading. Whereas very carefully the legislation does not use the word negotiation, it uses the word consult. Consult in good faith. Meaning you cannot just go along to your workers and say, okay, what do you think of X, Y, and Z? And then say, thank you for your opinion, and just go ahead and do whatever you damn well please. That certainly is not consultation in good faith. In good faith implies that you should listen carefully, that you should incorporate into your systems as far as possible their wishes and their demands even. And certainly that's in line with the new South Africa that we're heading towards. He's just got to make it happen. He's got to take what is in there, not only the letter of what is in there, but also the spirit of what is in there, and make sure that within his sphere of influence, the organization and the arrangements and the routine matters and the paperwork is in place, the training, to make it happen, to give effect.
How's he going to do that?
By the normal management procedures, by planning, by giving orders, by getting participation, by controlling, by delegation. All the ordinary, normal, day-to-day things that a manager does. Setting objectives, working out the action plans, targeting people, setting return dates, etc., etc.
And this would all be encapsulated in an audit?
Oh, indeed. Oh, indeed. As I said, controlling. Controlling is very much part of a manager's job. And he should be controlling that whatever he'd planned for, whatever objectives he had set, whatever action plans he had worked out, and whatever orders he had given, and whatever routine measures he had instituted, he has to control that and follow up on that and see that it is done, that it is complied with. That's what he gets paid for as a manager.
So who's going to be affected by this change in legislation? Who's going to fall under its jurisdiction? Well, from our viewpoint up here, we can get a very good idea of exactly who that's going to be.
As just mentioned, but worth emphasising, legislation now makes provision for the protection of everyone's health and safety who could be affected by the activities of any employer. And this too would include those who work in commercial and central business environments where the possibility of health and safety incidents are no less great, only different in nature. It still requires the same management commitment and dedication. Certainly the two largest employers in the land are central and local government, and the diversification of occupations within their structures demands the highest involvement in health and safety matters from all in management and supervisory positions. Even a task that to you and I would seem simple, changing a light bulb, takes on a whole new meaning for these municipal employees. The retail sector has an added dimension to their health and safety strategy, with the high degree of public involvement in their daily operations. Not only striving for service excellence, but also ensuring that no one is exposed to any unnecessary hazards or dangers. Hotels too have many special and particular applications as far as their range of occupations is concerned. Nothing can get in the way of their guests' enjoyment and needs. But even so, safety and health matters cannot be compromised for staff and patrons. Beyond the central business districts of our towns and cities are other situations where safety and health are an important part of daily life. Those in whose care we place our children have a special responsibility which is carried through to institutions of higher learning, such as our technikons and universities. And in these working environments, we once again find many areas of a special nature. Hospitals also have not only a commitment to those who need their speciality and care, but all those who work there too need the concern of management, especially in health matters. Occupational health and safety even reaches deep into the rural community. Industry is not confined to the city fringes. And farms too have become highly mechanized and sophisticated business operations, utilizing the most modern technology. But it is to industry that we finally turn, that area of working life that traditionally comes to the front of the mind when discussing health and safety matters. And it must follow that everyone has the right to expect concern and commitment by management to their health and safety at work. And they have the right too to be educated, trained and informed as to the hazards and dangers that are attached to their jobs, and also those that might exist in their working environment. Many companies such as Hearst, Shell Chemicals, A&CI and Eskom, to name but a few, have proven that an ongoing safety and health management program is essential to their productivity performance.
The one thing that every business operation or organisation has in common are the legal parameters within which they must operate to ensure the health and safety of their employees, or indeed anybody who could be directly affected by their activities. Ken Annandale, who has counselled many leading management teams on the subject, explains the new structure.
As you've just seen, this legislation applies to a broad variety of organisations. And at each of these organisations, they must establish a framework of this nature. The framework's called the Health and Safety Management System and starts off with the Chief Executive Officer at the top. Now, this person would invariably be either the chairman of the board, the dean of a university, or maybe even a town clerk. He in turn would have to appoint the employer. And the employer is the person who's charged with the regular daily running of the organisation. The employer does the assigning of various other people, and here we see the first major change to the structure. Previously, the employer was to delegate these people, but now in the new law, the employer assigns these people, and invariably they would be department heads or branch managers or people of that nature, who in turn have specific functions to carry out on behalf of the employer. The difference between the delegation and assignment, as we see it now, is that the delegation was a one-off function, whereas with the assignment, all managers or general supervisors now become assignees by a general gesture of assignment. This invariably incorporates these people into the structure and gives them additional responsibility as well. Now, the employer is responsible to ensure that an entire system is set up, and this system is called the Health and Safety Management System and focuses around the Safety Committee. This committee would be chaired by someone such as a manager or a delegated person and would be made up of various parties. In the past, the employer was responsible for designating certain people to this committee, and they were called safety representatives. But here's the second fundamental change. As the employer is responsible for ensuring that everybody is looked after by the system, he has to make sure that certain functions are carried out. And to do this, he now has the opportunity of nominating certain people. These nominees have specific duties such as inspections and investigations and so forth, very similar in the past to the old safety representative. However, there is now a new safety representative system, and they're called health and safety representatives. Unlike the nominees, they don't have duties, they have functions, and their functions are varied and optional. Let's have a look at how we arrive at deciding who the health and safety representatives are to be. As you heard Marnie Mulder speaking about the consultative process, we see the consultative process coming into operation over here. What the employer must do is he must consult with his employees or their representatives, and together they must decide how they're going to nominate or elect these people. Once the election has taken place, the employer is to designate these people, and they then form part of the entire system. The third group of people that sit on the Health and Safety Committee are the advisory members. Now, these advisory members would include people like engineers, the health and safety nurse, the safety officer, or even outside consultants. Now, it's interesting to note that the advisory members do not have a vote, while the other members of the committee do have a vote. You will note that there is equal representation from employer and employee nominees or representatives. Now, the Health and Safety Committee must determine its procedures or its constitution as to how it's to go about its functions. Now, this entire system is set up to protect a very specific group of people from dangers and hazards that emanate from the workplace. Let's have a look at these four groups of people. Firstly, we've got the employees. Now, those are obviously full-time employees at the company, or maybe even casuals or temporaries who work for the company. The second group of people that we've got there are non-employees. Now, those would be people who come to your organization with your blessing. They could be job seekers, they could be representatives, they could be consultants, people who don't work directly for you but are under your influence. Then we've got the third group of people, and they're the contractors and subcontractors, and they're commonly known as mandatories in the law. Now, let me just point out that unless you have the agreement with the contractor that he assumes responsibility for his own people and his activities, they are as much part of your workforce as if they were employees. Then there is the fourth group of people, and that's the general public. Now, this law specifically protects them from the hazards and dangers coming out of your workplace. This, once again, is a new emphasis and should receive special consideration. Here's an interesting inclusion. The law now says that if 10% of the employees in a specific workplace, such as a branch or even a department within your company, are unhappy about the way this is structured or the way things are going, they can go directly to the Department of Manpower, who will obviously intervene on their behalf. Even though this is self-regulatory legislation, the Department of Manpower will be monitoring the entire structure from time to time. While this is self-regulatory legislation, the law does allow you to make certain modifications to this entire structure. For instance, you can have more than one health and safety committee, just as long as each health and safety rep has the opportunity of sitting on at least one of the committees. Accountability has always been a thorny issue, and while the accountability rests squarely with the Chief Executive Officer, the assignments that are made in terms of this legislation would also mean that a certain amount of the accountability is transferred with the responsibility. Let me give an example. If a personnel manager fails to ensure that adequate training is conducted in terms of the Act, which says that 100% of the employees must be trained, he's going to expose his colleagues and the Chief Executive Officer to possible prosecution. Let's finally have a look at the question of the employer assignee. In the old Machinery and Occupational Safety Act, the employer was allowed to delegate certain functions and responsibilities to certain people. The problem with that was that they in turn couldn't delegate those functions. But now with the employer assignee is able to delegate certain functions and responsibilities as well. This makes the whole task a lot easier of managing the health and safety system.
Pressing Ken for a little more of his time, I spoke to him concerning the emphasis on training in the new legislation.
Not only did the legislation place almost no emphasis on the training of employees, nor did the popular safety organizations, and one specific instance where it was quite acceptable to train no more than 5% of the employees to attain a national award. And this has brought about an attitude of saying training is not important, but now in the new Act, we see it is. It says that 100% of the staff must be trained. Anybody who's exposed to any danger or hazard must be trained, together with the supervisor, together with the health and safety reps.
I've noticed there's a phrase called listed work. Could you explain that for us?
Well, they speak in the Act about the employer being responsible to identify all the dangers and hazards in the workplace. Once he's done that, the minister is going to declare a list of work, and he's going to say that if that corresponds with yours, then there are yet additional steps that must be taken. I'll give you an example of listed work. Probably working in a noise zone, probably working with certain chemicals or substances, working in a confined space, for instance. Those will be included, I'm sure, amongst the listed work.
South Africa is currently going through tremendous change, economically, socially and politically. Is it fair at this point to put what is seen by management teams as another restriction on their productivity, profitability, call it what you will?
Jamie, this is a question which I'm asked regularly. And while we have first world legislation and a third world situation, it must never be forgotten that we have first world technology, and together with the technology comes first world dangers and hazards.
Another equally important preventative measure is the introduction of biological monitoring and medical surveillance. The former concerns the regular checking of body fluids for the presence of any toxins or poisons that could be contracted from working with any chemical substances or processes. Medical surveillance, on the other hand, would be those regular physical checks to ascertain, for instance, hearing loss, breathing problems, eyesight and so forth, especially on joining or leaving a particular place of employment.
If we want to find out what is happening and the reasons why, then it's best that we look at the statistics that have been made available to us. For instance, last year there were over 8,000 serious incidents reported in the workplace. Now, 31% of those happened within the first 12 months of employment. If we increase that to 24 months, then the figure jumps to nearly 50%. If we look at fatal incidents in 1992, the figure was nearly as high as 600 people. But the startling statistic to come out of that was that 31% of those that died in the workplace were in their first 3 months of employment, and they were on their first job. Now this points to the fact that we need to give them more training, and even more retraining.
Training is vitally, fundamentally important in the management of health and safety. It is simply not acceptable to employ a person who works with an exceedingly dangerous substance and to spend all the 15 seconds telling him, listen fella, this stuff that you're working with is dangerous, okay? Be careful. And that's it. That is the end of his induction and training into working with highly dangerous substances.
Well, this actually happens.
Oh yes, I'm talking a practical case here, for which a prosecution at the moment. People have died. And having said that, we've become very callous to that fact. People have died. It doesn't mean much to you and I. Oh yes, on a certain level we have a sympathetic understanding of somebody dying. But imagine being the son or the daughter or the wife of that person who's a breadwinner. Been killed because the only training he got was, hey, be careful, this stuff's dangerous. And now he's dead.
That is, of course, where management does become extremely vulnerable, obviously.
Oh, indeed.
Because
indeed,
then the full weight of the law is going to come crashing down.
Yes, and well, to get back to your question about training, I think it's the old adage, knowledge is power. And if one knows about the hazards that you are exposed to in your working environment, well, then you can arrange your conduct and your way of going about your job in such a way as to not be injured or becoming ill.
So if the correct controls are not in place at the beginning, if the hazards haven't been identified and the risks not evaluated, then managers and supervisors could be exposing themselves to criminal prosecution and also that of their colleagues. Unreasonable?
As in the previous law, the new law is also based on the reasonable person. As you heard earlier on in the summing up of the magistrate, he referred to the reasonable man. And I think it is necessary for us to look at what is considered to be a reasonable man, the test for a reasonable man. May I refer you here to a person called the diligens pater familias, as it is known in legal terms. Now, if a reasonable man could with such a degree of probability foresee that he would injure or harm anybody else, then we apply 3 tests. And that would be that he would not have acted at all, or that he would have acted differently, or that he would have taken some preventive measures to ensure that there would be no harm or no injury. And that would be the test that is applied every time when the reasonable man comes up for discussion. In the court case earlier on, the magistrate referred also to reasonably practicable. Now, in our Act, on a regular basis you will find the use of those words, reasonably practicable. It is intended to mean that you don't have to do the impossible in order to comply with the law. Neither is it intended to mean that you have to go to ridiculous lengths to in fact avoid somebody from being exposed to a hazard. But we have thought it wise to include a definition in the Act of what is actually meant in relation to this Act by reasonably practicable. Here I would like to refer you to 4 parameters laid down. The first one will relate to the scope and the severity of the hazard or risk involved. Now obviously, if you are working with radioactive material, the scope and the severity would be much more than a person that is merely exposed to normal, non-irritant dusts. Secondly, the state of knowledge concerning these hazards or how to mitigate them, whether this information is in fact freely available. Now if in some obscure country somewhere there's information and this hasn't been published yet, then we cannot expect that somebody should have reasonably practically taken those steps. Thirdly, the availability and the suitability of the means to mitigate or to remove the threat. And that speaks for itself. And then fourthly, for the first time now, they bring in the cost of removing or mitigating the hazard, but bearing in mind the benefit derived from such removal or mitigation. While reasonability will obviously prevail, one must bear in mind that there is such a thing as vicarious liability, and this is spelled out in terms of Section 37 of the Act now. And it simply means that the employer will be held liable for any act or omission done by any of his employees, unless he can prove 3 things. And here we should look at this in rather more detail. In the first place, that in doing or omitting to do that act, the employee was acting without the connivance or permission of the employer. And then secondly, that it was not under any condition or in any circumstance within the scope of authority of the employee to do or omit to do the act, whether lawful or unlawful, of the character of the act or omission charged. And then thirdly, that all reasonable steps were taken by the employer to ensure that the act or omission of this kind could not be done.
It's not just a case, however, of being a reasonable sort of fellow and working within the bounds of practicability. While employers must provide and maintain a working environment that is safe and without risk to the health of their employees, there are also other specific duties that they must perform.
And these have significant changes from the old regulations that we found them in. In the first place, they now speak about the provision and maintenance of systems of work, plant and machinery, that as far as is reasonably practicable, are safe and without risks to health. And this would imply that one would have to have written work procedures. Secondly, it says that he must take such steps as may be reasonably practicable to eliminate or to mitigate any hazard or potential hazard to the safety and health of his employees before resorting to personal protective equipment. This, of course, joins on to the philosophy that we find in the general safety regulations pertaining to protective equipment. And that is that you first do away with the hazard, or you mitigate the hazard as far as is possible, and then only do you issue personal protective equipment. Then it says too that he must make arrangements for ensuring as far as is reasonably practicable the safety and absence of risks to health in connection with production, processing, use, handling, storage or transport of articles or substances. This, of course, also means that he has to keep up to date with the latest in technology. Next one is he must establish as far as is reasonably practicable. And I keep mentioning this because this is what the Act is based on. Reasonably practicable as we have defined it previously. Now he must establish as far as is reasonably practicable what hazards to the safety and health of persons are attached to which work that is performed, any article, substance, which is produced, processed, used, handled, stored or transported, and any plant or machinery which is used in his business. Here one would think that if you worked with a chemical substance, it would be his duty to obtain hazardous chemical data sheets, for instance, to make sure that he knows exactly what the hazards are relating to the chemicals he is working with. A further duty of the employer would be to provide such information, instructions, training and supervision as may be necessary to ensure, as far as is reasonably practicable, the health and safety of his workers. This is the first time that the Act is very specific about the training of employees. They must obviously be made aware of all the hazards in their area and trained how to handle this. A further duty is that he will not allow a worker to do any work unless precautionary measures are in fact put into place. This means that he has to put a prohibition on a worker, for instance, entering an area where certain protective equipment must be used, unless the employee is actually using that equipment. A further one is that he must take the necessary measures to ensure that the requirements of this Act are complied with by every person in his employment or on premises under his control where machinery or plant is used. And where we must also remember that this relates to every employer-employee relationship, not only to a factory, also to your commercial buildings, to your farms, each and every one of those situations. The same steps must be taken by the employer. Of course, it also means that he must train them into the Act. It says that he must make them aware of what is in the Act. And that predisposes that he would also have the Act available to be able to train them into this. Furthermore, he must enforce such measures as may be necessary in the interest of health and safety. And this has always been a prime duty of an employer, and that is to effect discipline in the workplace. A further duty is that he will make sure that work is performed and that plant is used or machinery is used under the general supervision of a person trained to understand the hazards associated with it and who has the authority to ensure that the precautionary measures are in fact put into place. Supervision is thus equally important. And then finally, the employer shall cause each of his employees to be made fully conversant with the scope of his authority. This to me means that he should have a job description available so that the man will know what his duties are as well as his responsibilities. We must bear in mind, though, that every time I mention the word employer, it does not necessarily mean the CEO himself. This may be one of those duties that he has chosen to assign to somebody further down the ladder of management.
We now know the reasoning behind the new legislation, the parameters within which we must work to set up and manage our health and safety management system, and also the general duties that are expected of managers and supervisors. If we choose not to comply, the alternative will prove very costly indeed.
This court has found you guilty of culpable homicide on each of the 3 counts. As you will no doubt imagine, the penalties for this are far more severe, 100,000 rands or 2 years imprisonment or both. As this is cumulative on each of the 3 counts, you are sentenced to a fine of 50,000 rands and a period of 6 months in prison. This will not be suspended.